Shiza, I had it muted. Okay, let me go ahead and start over. Hey, welcome. Thanks everybody for joining today. Really appreciate that. Today we're doing day 4 of the evidentiary hearing in the Skelton brothers case. John Skelton, the father, is on trial, if you will, or waiting to be tried, depending on how the evidentiary hearing turnout goes from the judge. The information being shared today are witness testimonies as well as documents and other discovery topics. Thank you, Antium. So, recap real quick. We had day 1. We had deeply emotional testimony from the boy's mother, Tanya Zuvers, who's divorced from John, and walked us through that terrible Thanksgiving custody exchange, followed by former pastor Donna Galloway recalling chilling statements Skelton made in the hospital. And as I said under mute, please watch day 1, part 1. It was chilling, trust me. Also, day 2, testimony shifted to Skelton's former employer regarding strange requests for Florida work runs, alongside a deep dive into Skelton's 2011 police interview, where he spun a wild story about an underground network called Joanne Taylor. You can watch that, but do a little speed, like 1.2, 1.5. Trust me, it's a long one and loud. Their audio was horrible. He kept tapping his pen or marker, and it was loud, giving me a migraine. So, day 3, the focus shifted closer to home and physical evidence. The court heard compelling testimony from family members, including a cousin and an aunt, testifying that the Skelton may have taken matters into his own hands. Along with heavy details regarding a discovered duffel bag, and close friend testimony highlighted dark conversation about it, the underground group. So we're not letting that one go. They're going to have to diffuse that one and find proof that it exists somehow from a defense perspective. If not, they don't go on the stand. Prosecution has to find proof to show there is no such thing. Today, prosecutors continue methodically binding together timeline constraints, physical indicators, and the total lack of credible alternative whereabouts for the boys. And remember, these boys were 15 years ago this occurred, 2010. So they would be young adults at this point. I'm not going through the timeline. I'll do that at a break. So with that said, let's go ahead and get started. And let me hit. Okay. So I skipped a long time that they were preparing. So should be getting started momentarily. John is now in the courtroom. And I'll go and meet.
Good morning, ladies and gentlemen. Today we are commencing a bit early. And we'll do that whenever everyone is here and we don't have any other docket items to consider. Who is your first witness?
Detective Mike Peterson.
Yes, I do.
Please be seated. Give me your first and last name, spelled out of the record.
Michael Peterson, Michael Peterson.
Peterson, I'm assuming that you've been in a few courtrooms.
Yes, ma'am.
Everyone is a little uniquely different. And if not for any other reason, because of the judge. But this happens to be a courtroom. We don't have video recording, we just have audio. So it will be very, very important that you speak your answers. And it may be a yes or no instead of or shrugging your shoulders, shaking your head. The microphone in front of you does not amplify
Yes, ma'am.
Sir, where are you employed?
With the Michigan State Police,
What is your current title?
I'm a detective sergeant.
What do you do in that role?
I am responsible for investigating complex crimes or sensitive crimes that would either take a trooper off the road for lengthy periods of time or involve high-profile individuals.
When you say complex type of cases, can you give me some examples?
Sure, I've investigated homicides, multiple homicides, murder for hires, armed robberies, cases that have a lot of evidence and require a lot of follow-up.
You indicated you're a detective.
Yes, ma'am.
How long have you been a detective?
Since 2014,
How long have you been with Michigan State Police throughout your career?
since 1998.
Can you walk me through your career?
Sure. I entered the 116th Trooper Recruit School in 1998. I graduated in July, and I became a road trooper. I worked on the road for 16 years. During that time, I also worked on Mackinac Island. I was an instructor at the training academy a couple times. I was on the tobacco tax investigation team, and I was a FTO field training officer for new troopers during that time.
Thank you.
And then after that, I became a detective in 2014.
During the course of your career, it sounds like you've done death investigations.
Yes, ma'am.
And when I say death investigations, can you tell me what types of deaths?
I've done accidental deaths, car accidents. I've investigated suicides as well as homicides and drug overdoses.
So when you talk about investigating suicides, is there typically a point in time where you would locate that individual?
Yes, ma'am.
Okay, and would that be in almost every suicide you've investigated?
Yes, ma'am. Well, if it's suicide, yes, we'd have to find the body. Yes.
Why is that?
Well, in order to do that, we'd have to for the medical examiner to determine it a suicide, we'd have to know the injuries and things of that nature.
And you said you've investigated accidental deaths and homicides, correct?
Yes, ma'am.
I've heard the term suspicious death before. Do you know what that term means?
It is a death where it is suspected that some sort of foul play or person was responsible, but it has to be proven.
When you come across a death in the capacity of your job and you deem that it's a suspicious death, what do you do?
We investigate, we start with a victimology, which is we learn everything we can about that person's life, and we start with their last contacts and their people closest to them and work our way out. We also investigate the crime scene, collect evidence, and based on all that, then the body is sent to the medical examiner for an autopsy, and the medical examiner then, based on the injuries that he's able to see on the body, and comparing that to the information that we have gathered from the scene and from statements made from everyone, makes a determination of cause of death and manner of death.
Okay, so he makes a determination as to the cause and manner of death.
Yes.
Sounds like a silly question, but can you tell me what the cause?
Sorry about that. I have to go over 3 screens to get my mouse back to hit the unmute button on the StreamYard. So I paused it here because this has been the issue over the last 15 years since 2010. No remains have been found. They have not located the 3 boys. Hence, in Michigan, to have a body to be autopsied to determine the manner of death indicates it is necessary to bring charges against someone. Okay. So over these been a lot of families and friends and regular citizens saying, please let this go forward. It was deafening to the prosecution's office. I've seen debates on YouTube about it through my research. I've seen an interview on Court TV. They did a follow-up a year ago. And what happened was finally a court approved death certificates for the 3 boys. So now the prosecution can say, we have death certificates officially stating they have passed. So now we want to move forward with the charges against the father who last saw them and all the suspicious activity he provided, plus the phone pings and traveling and all of his requirements that I mentioned earlier that he performed during that time. So that's why it's 15 years later. I don't want you to think that the Michigan law enforcement is slow or lazy. That's not the case. It was regarding the actual law as far as having a body or remains to be autopsied to determine the manner of death. So you may have already known that, but it was really an eye-opener for me as to why it took so long. So I'll restart. Sorry.
Of death could be
Sure.
Examples.
You could have a homicide, which is a direct killing of someone, an intentional killing. I'm sorry, that would be manner. The cause would be, for example, a gunshot wound. It could be a strangulation. It could be drowning. If you can imagine any way a person can die, that would be the cause of death.
okay. And the manner of death? Give me examples.
Sure. Manner of death, you would have natural causes or accidental death, suicide, or homicide.
When you have a case where the medical examiner reports back to you that the cause of death would be a homicide, would that be important to you as the investigator?
Yes, it would.
Why is that?
Well, the medical examiner, if he were to come back and say that a case is natural, if we're talking, you mentioned before, you brought up a suspicious death. If it's suspicious, but he determines that it's natural, say the subject had a heart attack, well, then it would rule out that this was a homicide. However, if he found obvious injuries on the subject, the deceased subject, that there's no other way to account for them but by the hands of someone else, then he'd rule it a homicide. So that would be important. It is crucial for us to determine for our case.
And that would be considered a piece of evidence for your case.
Yes, ma'am.
How many homicide trials during the course of your career have you either been a part of or as the direct investigator or been a part of on the outside of?
Probably 8, roughly.
And have you attended all of those trials?
Yes, ma'am.
And does the medical examiner testify at those trials as to the cause and manner of death?
Yes, ma'am.
I am going to, Your Honor, may I approach the witness? So I've handed you People's Exhibit 47. Now, just to be clear, Your Honor, Mr. Amadeo and I have already stipulated to the admissibility of this for preliminary exam purposes.
I am in receipt, but Your Honor, I have reviewed and I do step.
So just to be clear, sir, you did not create this report, correct?
That is correct.
Okay. And can you read the title on the very first cover page of what this document is, what this report is?
It is a forensic examination report.
And for what case number?
Case number CCU-3579-2025.
And this packet, this exhibit that I've handed you contains 15 pages, correct? If you can look at the last page. And
Yes, the last page is 15, yes.
can I have you flip to page number 3? Can you please identify which item this report relates to?
This report relates to a Hitachi, this is 40 gigabyte Hitachi HG.E01. That's a Hitachi computer.
Thank you. I'm going to have you turn to page 4 of that report. Can you tell me what the very top of that page identifies this document?
Yahoo Diagnostic Chats.
And each chat is labeled as a record, is that correct?
Yes, ma'am.
All right, so I want you to look at the first one, record 1, and the gray portion of that. Tell me what information each record gives.
So record number 1 says tags, and it is of interest. Local user is EQCILDAAN.
I'm going to stop you there real quick.
Sure.
Can you just read the record, the information that's given in the
gray?
gray shaded portion, please?
Yes, ma'am. Tags, local user, sender, recipient, chat sent, date/time, local time, message, command, type, source, location, evidence number, recovery method, item ID.
And can I have you flip to page 15 of that document?
Is that 1.5?
1.5, I'm sorry. And that ends with record number what?
Record number 42.
Okay, and so for records 1 through 42, that gray portion with the information that would be for each record is consistent, correct?
Yes, ma'am.
All right. I'm going to start with record number 1. Can you identify who the sender of that Yahoo Diagnostic Chat was?
The sender is identified as, and I'm going to spell it, and then after that I'll just say it as best I can. It's EQCILDAAN. I'll say Akildon.
Okay. And then who was the recipient of this message?
It is KATRACHAN at rocketmail.com. Katrakhan at rocketmail.com.
Do you want to refer to that one as cat from here on out?
That'll be fine. Yes, ma'am.
On record number 1, what is the chat sent date, time, local time?
11/18/2010. Local time would be 14:46 or 2:46.
Can you read the message that is contained in record 1?
This is from Kildon to Cat. Hello there.
Record 2, can you indicate for me again who the sender, recipient, date and time, and message?
Sender is Cat. Recipient Kildon. 11/18/2010, 2:48. The message is hey.
Record 3, can you please do the same?
Sender is Cat. Recipient Kildon. 11/18/2010, 2:48. Message, sorry for the long delay.
Record 4,
Sender is Cat. Recipient Kildon. 11/18/2010, 14:48 or 2:48. The message from Kildon is headache.
record 5,
The sender is Kildon. Recipient is Cat. 11/18/2010, 2:49. Kildon said, "It's fine. I'm used to it from the wife who doesn't like me anymore."
record 6,
Sender is Cat. Recipient is Kildon. 11/18/2010, 2:49. Kildon said, "So no change?" Question mark.
record 6. Oh, record 7, I apologize.
Sender is Kildon. Recipient is Cat. 11/18/2010, 2:50. Kildon said, "Went from good to bed, then to worse."
Record 8,
Sender is Kildon. Recipient is Cat. 11/18/2010, 2:50. Message, It will all end this weekend, though.
Record 9.
Sender is Kat. Recipient is a Kildown. 11/18/2010 at 2:50. What's this weekend? Question mark.
Record 10.
Sender is a Kildown. Recipient is Kat. 11/18/2010, 2:51. I'm giving up.
Record 11.
From a Kildown, it's a sender. Recipient is, the sender is Kat. Recipient is a Kildown. 11/18/2010, 2:51. I'm very sorry, hun.
Record 12.
The sender is a Kildown. Recipient is Kat. 11/18/2010, 2:51. A Kildown said, she wants to be alone, then she will be alone.
Record 13.
Sender is Kat. Recipient is a Kildown. 11/18/2010, 2:52. Kat stated, give her a little space. If you want at least a friendship eventually.
Record 14.
Sender is a Kildown. Recipient is Kat. 11/18/2010, 2:52. I'm well on the path to hurting her so much anyway. Might as well complete the job. LOL.
Record 15.
The sender is Kat. Recipient is a Kildown. 11/18/2010, 2:53. You want a friendship for the kids. Remember that.
Record 16.
The sender is a Kildown. Recipient is Kat. 11/18/2010, 2:53. I can't. I am so empty without her. I resented her a lot for not helping me provide for the family, but my time alone in Florida helped me.
Record 17.
Sender is Kat. Recipient is a Kildown. 11/18/2010, 2:53. Gotta go to work, hun. Sorry I can't talk more. Please feel better.
Record 18.
11/18/2010, 2:54. Kildown said, tell her that.
Record 19.
Sender is a Kildown. Message, the recipient is Kat. 11/18/2010, 2:54. Kildown stated, goodbye. You were a great friend.
Record 20.
The sender is a Kildown. Recipient is Kat. 11/18/2010, 2:54. Kildown sent the message, tell Isaac and Tiana I said goodbye too, please.
Record 21.
The sender is from Kat. Recipient is a Kildown. 11/18/2010, 2:56. The Kat said no goodbye.
Record 22.
The sender is a Kildown. The recipient is Kat. 11/18/2010, 2:56. Kildown said, it's too late now, sweetie.
23.
The sender is a Kildown. The recipient is Kat. 11/18/2010, 2:57. The message, I have lost 50 pounds in 2 months. I've lost everything.
Record 24.
The sender is a Kildown. The recipient is Kat. 11/18/2010, 2:57. Kildown sent the message, no money, no friends, close here. Tanya won't do shared custody.
Record 25.
The sender is Kat. Recipient is a Kildown. 11/18/2010, 2:57. Kat sent the message, no.
Record 26 appears to be somewhat out of order, but go ahead.
Sender is a Kildown. Recipient is Kat. This was on 11/10/2010 at 8:25 p.m. Akildan said, "It feels like Tanya is just stringing me along."
Record 27.
27, the sender is Akildan, recipient is Kat. 11/18 of 2010 at 2:58 p.m. Akildan said, "My will is gone. I am empty."
Record 28.
Sender is Akildan, recipient is Kat. 11/18 of 2010 at 2:59 p.m. Akildan sent the message, "Made preps for things to be done. Tomorrow is my last day of pain."
Record 29.
The sender is the sender is Kat, recipient is Akildan. 11/18 of 2010, 3:01 p.m. The message from Kat is no with an exclamation point.
Record 30.
Record 30, the sender is Akildan, the recipient is Kat. 11/18, 2010, 2:58 p.m. Akildan sent the message, "Won't touch or hug or kiss me, barely talks to me."
Record 31.
The sender is Akildan, recipient is Kat. 11/18, 2010, 3:01 p.m. The message is from Akildan, "Take care of that baby."
Record 32.
Record 32, the sender is Akildan, recipient is Kat. 11/18, 2010 at 3 o'clock. It says the message from Akildan, "You go to work and just remember you once knew a man that was a good husband and father named John."
And record 33.
Record 33, the sender is Akildan, the recipient is Kat. 11/18, 2010, this is 2:58 p.m. Akildan sent the message, "I have given every possession I have away."
I'm going to go ahead and have you stop right there. And again, that was record 34, and there's 43 on there. Is that accurate?
Well, we stopped at 33,
33. Okay.
and
Thank
there
you.
are 42 on there.
Okay. I'm going to switch gears a little bit. Did you become involved in this particular case at some point in time?
Yes, ma'am.
Do you recall approximately when that was?
Approximately a year and a half ago, roughly. I mean, I've received calls at the post for a decade about this. Occasionally, I'll get a tip or something that I would typically forward on to Lieutenant Brewer, but I became actively involved about a year and a half ago.
Was there a point in time where you had contact with John Skelton?
Yes, ma'am.
Do you recall what day that was?
It was November 3rd, 2025.
And do you recall where that was?
It was at a prison. Offhand, I don't remember the prison. It's in an interview room, though, at the prison.
Prior to going up and speaking to him, had you done any looking into his previous statements?
Yes, ma'am.
Where did you meet with him at the prison?
It was in a conference room in the prison.
Does Bellamy Creek facility sound familiar? Is that
Yes, ma'am.
okay? And at the time that you go in this conference room with John Skelton, did you read him Miranda?
No, ma'am.
Okay. Did you advise him of anything else?
I advise him of what are called behealer warnings. It's when someone is not in custody, but you are wanting to question them. So behealer warnings are essentially you're telling them that they're voluntarily, they're free to leave or stop answering questions at any time. I will show them that the door is unlocked so they don't feel like they're in any way locked in or are caged in at all. So I advise them of those.
When you say not in custody and he's in prison, can you explain what that a little bit more about that?
Yes, ma'am. So Miranda warnings typically apply to people who are in police custody. He is not in police custody, and his prison is his home. So he's free to, if he wants to come and talk to me, he can. He is also free at that time when whoever went to get him, the guard or the inspector, he's free to say, I don't want you to talk to the police, and he can stay in his home, his cell. And so that's why he's not, for purposes of Miranda warnings, he's not considered in custody.
Okay, so you did advise him, he didn't have to talk to you and he didn't have to be in that room with you at that time, correct?
That is correct.
All right. Specifically as it relates to the early morning hours of Friday, November 26th, 2010, did you have a conversation with John Skelton about that?
Yes, ma'am.
Tell me about that.
So he had talked about the process of giving his kids away, his boys away, and to a group called Underground Sanctuary. And he stated that someone by the name of Joanne and Virgil left with his kids at 12 a.m. on the 26th, which would have been, as Thanksgiving had turned over to 12 a.m., just for clarification, that they left around 12 a.m.
Okay, so Thursday, Thanksgiving night, going into Friday, the 26th.
That is correct.
Okay, go ahead.
He stated that, I quote, they left and I burnt everything.
Okay.
Okay, so I asked him why he burnt everything. He stated he wanted to kill himself and that he didn't want Tanya to find the kids.
Okay.
I asked him why he didn't he stated that he felt regret immediately for giving away the kids. And I stated, well, why didn't you try to get the kids back instead of killing yourself then? And he said, I did. He stated that, and I asked him to tell me about that, about his attempts to get the children back. And he stated that he went to Holiday City, where Joanne and Virgil from Underground Sanctuary stated they would be that night, that they would be in a big truck in a restaurant or diner parking lot, though he was unable to remember the name of the restaurant. And he stated that he went there to Holiday City in Ohio at approximately 6 or 6:30 in the morning, or a few hours after that they left his residence.
So he said he immediately had regret about giving them away, and then he didn't return to go find them though until 6 a.m. Is that accurate?
That is accurate,
Okay.
yes.
So he indicates that they tell him they're going to stay in Holiday City for the night. Is that accurate?
Yes, ma'am.
Now, again, before you go in there, you reviewed everything up until that point. Is this consistent with previous statements?
Is what consistent? Which part?
The Holiday City part. Thank you for asking
Yes.
for clarification.
No, ma'am.
Okay. And why is it inconsistent?
In previous statements, he had said that he did not leave his house.
So this is the first time he's acknowledged to you that he's in fact left Morenci.
That's correct.
Thank you. I have nothing further.
Thank you. Good morning, Trooper. How are you?
Outstanding, sir. How are you?
Good. So, you did not read Miranda to my client, correct?
That is correct.
Now, did you tell him you could stop the questioning at any time?
I stated he could leave at any time.
But he couldn't leave, isn't that correct?
He could leave. Yes, he could. I even demonstrated that the door was open.
Remember when he told you you can't just leave, you have to get permission to leave towards the end of the interview?
Right. That doesn't constitute custody, though.
That wasn't what I asked you, sir.
Okay, so I don't remember that exact statement, but I don't know.
Now, you mentioned these text messages. Who is Kat?
I don't know, sir.
Did you do any research on that?
No, sir.
All right. Did you review all the evidence in this case?
Can you repeat that question, sir?
Did you review all the evidence in this case?
I have not reviewed all the evidence, no, sir.
And you said you've done 8 homicides, is that correct?
Roughly.
All right. In all those homicides, was a medical examiner always testifying?
And all the ones that I was involved with, yes, sir.
Okay, how many of the 8 that you've done was there no bodies?
None, sir.
So this would be the first one.
Yes, sir.
Do you say it's a problem at all?
I don't understand that question, sir. What
Do you think it's problematic to prosecute someone without bodies for a homicide as in your profession?
it's more difficult, but it is, I don't know what you mean by problematic.
Did you review the camcorder that's been put in evidence?
Camcorder for what? No, I did not, sir.
How about the duffel bag?
No, sir.
How many times did you meet with my client?
How many times did I speak with him?
Yeah.
One time, sir.
Did you notify him you were coming?
No, sir.
Did you tell him you were recording it?
No, sir.
Why not?
It's not required, sir.
So you weren't honest with him, correct?
I was honest with him because I didn't tell him doesn't mean I was dishonest.
Well, didn't you actually tell him you don't know if charges were being brought?
I told him that I couldn't promise they weren't going to be brought
When did you interview him?
on November 3rd,
And when was-
2025.
What was his out date from prison? Do you know that?
It was approximately 2 weeks later.
And when were charges brought against him?
I don't remember, sir.
When
Probably
you-
Go ahead, sir.
When you went there, did you know he was being charged with homicide or not?
Yes, sir.
And did you tell him you didn't know?
I told him I couldn't promise him that he would not be charged.
So you lied to my client, correct?
That's not a lie. I couldn't.
It's not a lie?
I couldn't promise him that he would not be charged. That's not a lie.
Well, hold on a sec. Educate me, please. Did you tell my client you didn't know he was going to be charged, and did you just answer you did know he was being charged? And how is that not a lie?
Objection, asked and answered and argumentative.
I just want clarification.
Well, it certainly is argumentative, but I understand the nature of the concern. If I understand correctly, at the time that you interviewed him, you were aware that murder charges were already pending?
We're likely imminent.
Okay, so they had not yet been issued.
Correct.
And you indicated to counsel that you believe they would be forthcoming, however.
I believe that as far as I recall, I told him I could not promise him that he would not be charged.
Did you review the interviews of Pastor Galloway for this case?
No, sir.
You didn't.
No, sir.
Did you review any of the interviews? for this case?
I read that what they said. So if by review, I thought you meant did I watch them?
Based on your review of the case, is there any physical evidence linking my client to the bodies of these children or the deaths of them?
To the deaths of them,
Any physical evidence?
there's no physical evidence right now.
Do you have a weapon?
No, sir.
Do you have a body of any kind?
No, sir.
Isn't it true that all you have is speculation?
Well, we have circumstantial evidence.
Circumstantial,
Yes.
right. Got it.
Objection to the,
But its very nature was editorial but because it's a hearing before a magistrate, quote unquote, judicial magistrate, I think I can take the answer and the question and the attitude for what it's worth.
thank you.
What new evidence do you have from your time you're on the investigation that was not presented in 2010?
Go ahead.
Objection, presented to who?
I'll rephrase. What new evidence have you found in your investigation that was not available in 2010?
His inconsistent statements with my interview with previous interviews.
So, inconsistent statements. That's what you guys have?
Objections asked and answered.
I want clarification.
Again, your lack of, your belief in his lack of credulity is noted.
Thank you.
But the bottom line still is that this is my decision ultimately,
I understand, Your Honor.
and while you're incredulous, and that's your job, I don't think it's necessary to express that in this particular arena. It's not going to help anyone.
I understand, Judge.
I certainly understand your concern.
Have you found inconsistent statements between the witnesses over the years?
I've not reviewed them that carefully, sir.
Nothing further.
So to be clear, while you were at Bellamy Creek facility in the conference room, you showed John, there's the door. Get up and leave if you want.
Yes, ma'am. In fact, I actually stood up and walked over and opened the door to show him that he could leave.
Mr. Amadeo asked you if out of all the homicides that you've worked on over the years, you've never worked on a no-body homicide case, correct?
That's correct.
You did, in fact, work on a case that began as a no-body homicide case in November of 2023, correct?
Yes, ma'am.
All right. And do you know the result of that case?
The defendant was found guilty.
Do you have children, sir?
Yes, ma'am.
And the fact that we have 3 boys, ages 9, 7, and 5, who are not capable of taking care of themselves and disappear in the middle of winter, is that some of the circumstantial evidence that you're talking about here today?
Yes, ma'am.
Just a small portion of the
Yes,
evidence,
ma'am.
correct? Nothing further.
What was the case you started that had no body?
It was the D. Warner homicide.
And when the prosecution got a conviction, they actually found the body, didn't they?
They had found the body. Yes, sir.
Thank you.
Okay. We're gonna take just a brief recess, and I'm going to ask counsels to meet me in my chambers.
All right, please. Thank you.
Yeah, oh yeah, absolutely. We're all with. We don't have it, we used to.
Okay, so they're just lingering around in there waiting for them to come back. But I do find it quite interesting that the judge wants to see them in chambers. Now, I believe it's because they're going back and forth on the same responses, the objections and the responses. I just want clarity. So you're kind of caught in a gray area there, right? She understands that she tried to explain to them, but I think she wants to meet with them together, in chambers, to discuss and explain in more detail so that they both understand. There were a lot of agreements on day one, right? Things that they would allow, not having to object every time, certain things like that. That's my assumption for why they went into chambers. Now, how long it's going to take, I don't know, but we're going to stay here and keep watching. See what other info I can share. So today was emphasizing so far that this is a preliminary examination, not a full trial. We all know that, or we should. It's to determine the probable cause, if there's enough evidence to bind the John Skelton over on open murder charges nearly 15 years after his son's. have vanished in 2010. Highlight testimony from lead investigators and forensic experts will be forthcoming, except currently we have the officer on the stand. Forensics experts detailing the timeline. November 2010 will be coming up. Focus on his evasive statements, conflicting stories regarding handling of the boys over to the underground group, and cell phone ping records. So we're going to see some information forensically that's going to give us like a map view, his travel arrangements, where he was at different times. So that'll be quite interesting to see. With technology of today that was not available probably 15 years ago, they probably have a lot more information that ties him to the reason for having a charges against him, other than the obvious. Skelton previously served prison time after pleading no context to unlawful imprisonment, but prosecutors are now presented accumulated forensic data, expert options, and circumstantial evidence aiming to establish probable cause for homicide. Ooh, razzmatazz. That's wild. And it took 3 years. Oh, I'll let you all see it. Razzmatazz writes, Dee Warner's husband welded her body inside a fertilizer container and took 3 years to find her body. That's only 3 years. In my Missing Spotlight series, I'm going back to the 60s. People have been missing. So it's gut-wrenching for the family and friends, but thank you for sharing that. That's amazing in itself. And that reminds me, this would be a good time for me to go here. If I can get to me. What else? The defense strategy and scrutiny highlight defense arguments likely to challenge to the heavy reliance on circumstantial evidence, historical timeliness, and shifting statements made under extreme emotional distress or psychological evaluation during his initial arrest. So those are just to keep you up with some information, which is kind of interesting in itself. Let me go in here. Pause. Okay, I'm sending out 5 free memberships to my channel. Dun, 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 dun. So hopefully folks here will get them. I'm looking forward to you having them. You can see other membership related stuff. And hopefully I'll see you joining some member streams if I go forward and create some additional ones. But there's stuff out there that you can look at. And it's kind of nice because membership means I can be more free with my verbiage, which I will. I'm just saying. But this stuff is really interesting. Oh, you're very welcome, Auntie M. Of course. Close that. This. So I'll let them murmur around. Maybe we can overhear something. That could be interesting. One moment, please.
They don't have so many brand names. Okay. Could they go to? So they're not NHSA. But they're not in the okay. That's cool. Like it's so much fun. The baseball circuit. Tournaments all over the place. It's awful. Yeah, I'd say it's awful. When it first it was like, this was fun. The parents had it, and that was fun at the time, but it was just good. It was every weekend here in town. I stayed in town. It was fun. It was so much fun. Okay.
Sit out of here. Yes. Yeah, I can do that. You're gonna have more of an experience. Yeah.
Yes, so, yeah.
You're gonna make more
It's nice.
memories.
You understand 100%. But imagine if you rather lose at D1 or be a station at D4.
Exactly. Yeah, you're gonna remember more and have more fun with that group.
So,
Yeah.
where's your son? Oh, just.
Yeah. So if you was a freshman, yeah. That group is so, it's eighth grade. They wanted to see you play in, yeah, as a freshman, that team, they wanted to get. So, so he was a under, but he really would be like 6'1". So that night he was just, so. He was a spun. They had all like 4 All Staters and lower All State and down there. They made it to the 7th to the quarterfinals out the year. But it was school department state championship. We were playing some schools. Go through 12. So high school, yeah. But they just had some kids that played all the way through. But all those things that you're all playing. But it was just a lot of fun. And they've sucked since then because they just haven't, these not as a kid. Like, now you're a basketball school for 3 years. Now you're a baseball school. It's hard. They don't have the. Yeah. And for our guys, it was nice because his school was a baseball. There's some amongst his buddies in baseball. So they got called. That's where the game was played, in the region. But it's just fun in a small school. Parents, it's all it's not. There's no funding for any of this. That's awesome. And so you're playing against these schools that are coming in all the regions.
Oh, wow.
Is it like YouTube stuff you did? Yeah.
Anyway,
Talk about our bad issues. Form goes. I was like, yeah, get to everything. It started like the BS guy was you saw that it was still there, and he's like, you're good. Like, thank you. Yeah. Yeah, he tweets that. I know. Hey. I'm glad someone's seen the ability to do that. He's like, I'll be statue for a reason. Can't really move too much. What's money doing? They didn't understand why I thought it was so funny.
Oh, it's hilarious.
Uh-oh, beginning to think addressing a bad idea. Feel that air blowing.
Well, you're stiff. Reserve all comment on that one.
All right, sweetie. Maybe she.
I have no further questions of this witness, Your Honor.
Cross-examination.
I have no further questions.
You may be released and you may stay in the courtroom, I assume?
Yes.
If you wish.
Thank you, ma'am.
No objection.
It's my understanding that we don't have any further witnesses for this morning, is that correct?
That's correct, Your Honor.
Again, I would indicate that the difficulty is that we never know how long a witness is going to take. We will resume as close to 1 o'clock as your next witness can make it. If they can make it a little bit earlier, if you just let us know, we'll make sure that folks get our advice.
Your Honor, sorry, I apologize. Prosecutor Wise, who are the two witnesses this afternoon, just so I can do a little extra prep? I know it's Michelle Lampier.
And Christopher Hess.
Thank you. Thank you, Judge.
Thank you. And again, if we can resume a little bit earlier, we will try and do that.
Thank you.
Thank you.
At this point, we'll look at 1 o'clock.
All right, sweetie.
It's 2 minutes.
That's just an awesome picture of those three boys. They're just so sweet looking, you know, probably just typical little children that played and got on their parents' nerves, but not enough to take their lives. So with that, we are on a lunch break. She said they'll start back. I don't like streaming with nothing on it, you know, so I'll start a new stream for part 2 today, day 4, part 2, and I will watch for the startup. I'm going to give it, I have to keep counting because of the time difference. So about an hour from now. Let's do that. Now they could start earlier, so I may hit the thing, but I'll be monitoring, you understand. So let's end the stream here. I thank you all very much. I really appreciate you attending. I'm looking forward to any future this afternoon's additional witnesses to be on the witness stand and just watch the defense attorney try his best. We'll leave it at that. Okay. Thank you all. See you at the next one. Bye.